So the end of the year is fast approaching, and for so many people, especially here in South Africa, there's this deep, almost spiritual reliance on a financial boost.
That year-end bonus or the much hoped for 13th check?
Exactly. It's what helps ease the pressure of the festive season, maybe cover school fees, or just, survive January.
It's way more than just a financial transaction, isn't it?
Mm.
It's a huge cultural and psychological expectation. But the question that keeps coming up,
Mhm.
and it's the one we have to address, is does this expectation have any legal teeth?
Mm,
Are employers, under South African labor law, actually required to pay you this money?
that's it. We're diving deep into what is often a really stressful assumption. Is this a guaranteed right? Is it a contractually binding thing? Or is it just a generous gift the company can pull back whenever it wants?
Well, our mission today is to cut through all that confusion.
Yeah.
We need to clearly define the legal difference between, say, a guaranteed payment and a discretionary one.
And nail down where an employee's security actually lies.
We have to find the source of the obligation. Because if the law doesn't explicitly mandate it, then the answer has to be somewhere else.
In the relationship, the contract.
Or in the history of practice. We have to define that framework.
Okay, let's unpack this right now with the foundational fact. If you look at the Basic Conditions of Employment Act, or any generalized South African labor law, really, the position is crystal clear.
And it's probably not what people want to hear.
No, employers are not automatically mandated by law to provide year-end bonuses. It is not a statutory requirement.
That's the critical starting point. If you, the employee, are looking to the law for some kind of blanket guarantee of a bonus, well, you won't find it.
So any legal obligation an employer has to pay you that extra amount must come from somewhere else.
It has to originate from specific, agreed-upon terms,
Yeah.
something defined within your own employment relationship.
Okay, so if the government doesn't require it, where does an employee find that security? Our sources point to three main areas where this obligation can actually solidify. The first one is the most secure, and it's pretty straightforward.
The employment contract itself.
The contract.
Absolutely. The contract is the highest authority here. If your contract expressly states that you are entitled to a bonus, or even better, a guaranteed 13th check,
Then it's a done deal.
then that money is a contractual debt. The employer must pay it. It doesn't matter how the company performed that year, unless, of course, the contract specified some condition that wasn't met.
But the obligation isn't just stuck in that one piece of paper you signed on day one, right? Where else can you find that legal promise?
You have to broaden the scope. Look at any documentation that governs how the workplace runs day to day.
Like a staff handbook.
A staff handbook, formal company policies, or even a collective bargaining agreement that was negotiated with a union. If those documents outline clear, measurable criteria for a payment, they become legally binding, almost as powerful as the contract itself.
Okay, now this is where it gets really interesting for me, because the source material brings up a much trickier, more subtle legal idea. The influence of consistent long-term practice. Let's say you don't have it written in your contract or in the handbook, but for the last 8 years, every single December, the company has paid everyone a 10% bonus.
And it's always been based on, say, the company hitting a certain revenue target.
Yes, exactly.
This is where the law steps in to interpret what the parties intended, even if they didn't write it down perfectly. That regular, predictable payment of a bonus, especially when it's tied to clear criteria and isn't just some random gift, can establish what we call a reasonable expectation of payment.
Hold on. So an expectation, which sounds, emotional, can actually become a legal right. That feels like a massive gray area.
It is complex, and it definitely requires a case-by-case assessment. But think of it this way. If an employer consistently pays a bonus like that, it starts to shift the nature of that payment from an unexpected gift to an implied term of your employment.
So you've been banking on it for years.
You've been banking on that 10% for years based on hitting your targets. And then suddenly, without a good reason, they withdraw it. Well, you have a much stronger legal argument than someone who just got a random one-off payment 5 years ago.
Consistency is key then.
Consistency and the clarity of the criteria. Those are the keys.
It makes the employment relationship sound like Like an archaeological site. You have to dig through years of history to figure out what was actually promised.
Precisely. It shifts the whole conversation from what the law mandates to how we legally interpret past behavior and intent.
Okay, so before we get into what happens when those payments are withheld, we have to address the basic vocabulary. We keep using two terms almost interchangeably, the bonus and the 13th check.
We need to clarify the difference.
Yes, let's clarify that critical difference because it really determines your level of security.
It's probably the single most important clarification we can make. A 13th check is, by its very definition, a guaranteed annual payment.
It's structured differently.
Exactly. It's basically your annual salary split into 13 payments instead of 12. If your contract specifies a 13th check, think of it as deferred salary. It doesn't depend on company performance or your manager's mood.
So if the 13th check is guaranteed, it's pretty much immune to a bad year for the company.
It should be.
Now, contrast that with the typical year-end bonus.
The bonus is almost the complete opposite. It's generally classified as a discretionary benefit. It's variable. It's contingent on meeting specific outcomes.
Your performance, the company's performance.
Right. Either individual goals or the company's financial success.
Right.
Because it hinges on all those variables, the bonus is inherently less secure.
But I'm guessing the language used is crucial here. Could an employer call something a bonus but still contractually guarantee it?
Oh, yes. The terminology in the contract is what matters, not the common name people use for it. A performance bonus that's tied to a specific guaranteed formula starts to operate a lot more like a 13th check.
And on the flip side,
If the contract says annual bonus, subject to the sole and absolute discretion of management, then you are on much shakier legal ground. Which brings us to that crucial point. Discretion.
that's the word I want to challenge. If a payment is labeled discretionary, does that really mean an employer can just act arbitrarily? Can they punish an employee they don't like by just saying they use their absolute discretion to withhold the money?
That is the assumption a lot of employers make, and it is legally flawed. Even when a bonus is explicitly labeled as discretionary, the employer's decision-making power is not absolute. It's not immune from scrutiny.
So they have to be fair.
They must exercise that discretion fairly and lawfully.
And what does that look like in practice? What keeps the employer in check?
Two things, really. First is rationality and good faith. If there are established criteria, say the company hit its targets, the employer has to apply those criteria rationally. They can't just invent new reasons to deny the bonus.
So they can't move the goalposts after the fact.
No. If they say the company didn't do well, they need to be able to demonstrate that through the books. And the second, and perhaps the most powerful check, is the protection against bias.
You mean under the Employment Equity Act?
Precisely. That is the non-negotiable legal safeguard. Withholding a bonus based on prohibited grounds, like your race, gender, pregnancy, or religious affiliation, is straight-up unlawful discrimination.
So an employer can't use the discretionary label as a shield for that kind of behavior.
Absolutely not. This is where the law says you may have discretion, but you must still obey the Constitution and the core labor statutes.
That provides a huge sense of security. So if we look at the entire governing framework, it's not just the contract. It's the contract first, company policies second, and then this overarching labor legislation that ensures fairness.
Correct. And this is where we need to connect the dots for you, the listener, about the role of the Basic Conditions of Employment Act and the Labor Relations Act.
Right, because they don't mandate the bonus.
No, but they provide the machinery to enforce the rights that do exist.
So they govern the dispute process. How does that work?
Well, if you're entitled to a guaranteed 13th check, which is essentially just unpaid wages, the BCEA governs that, you can pursue the non-payment as a violation of basic conditions.
And if it's a discretionary bonus that's been denied?
If the issue is an unfair denial, say you met all your performance metrics, but the bonus was withheld arbitrarily, the LRA provides the framework for you to challenge that as an unfair labor practice. These acts give you the legal avenue to seek recourse.
Okay, let's get practical. If you believe you have a promised payment, whether it's guaranteed or you can show you earned it based on clear criteria, and you don't get it, what are the actual steps you can take?
The first step is to formally lodge a dispute. Usually that's with the CCMA. The basis of that dispute is critical. It's either breach of contract, if the terms were explicit, or, as we just discussed, an unfair labor practice.
And what should employers be doing right now to avoid these disputes? It sounds like clarity is a lot cheaper than a lawsuit.
Absolutely. The need for transparent communication from employers just can't be overstated. If a bonus is genuinely discretionary, that has to be communicated clearly, frequently, and it needs to be documented.
So there are no surprises.
No surprises. If the criteria change from year to year, employees need to know that in advance. Clear, documented expectations build trust, and they prevent the creation of these unintended reasonable expectations that the company might not be able to afford later.
This deep dive has been incredibly clarifying. We've moved the conversation away from just hope and into the realm of legal certainty. To recap the main points for you. First, any legal obligation for a year-end payment is contractual or comes from consistent practice. It's not automatic in South Africa.
Second, always distinguish between that guaranteed 13th check, which is like deferred salary, and the variable performance bonus. The language in your contract makes all the difference.
And finally, even when payments are discretionary, the employer's decision has to be rational, it has to be applied in good faith, and it must comply with the Employment Equity Act, protecting you from discrimination.
The law may not give you the bonus, but it ensures fairness in how it's applied.
Yes.
And that leads to a crucial final thought for every person listening. Given that South African labor law doesn't mandate these payments, what is the single most important document you should review right now to understand your entitlements before December?
It has to be the specific language of your individual employment contract, backed up by the company's official staff handbook or bonus policy. Don't rely on rumor or water cooler talk.
Know your fine print. That is where your financial security for the festive season is actually defined.
And finally, as always, please remember that the content in this deep dive is strictly for informational purposes. It does not constitute legal advice. If you find yourself in a dispute or have specific legal questions, consultation with an experienced labor attorney is strongly recommended.